Yeah, I guess I gotta pee. What's bad?
Mr.
I
McFarland?
gotta pee, Mom.
Hold on,
I gotta pee. I gotta pee.
Mr.
I
McFarland,
gotta piss now. I got gas in my lung, my kidney. I gotta pee. I gotta pee.
You're-
You want to pee on myself? I gotta pee. To take a bath, I gotta pee.
is there a bathroom back there?
Yes.
All right, let him use the bathroom and then we'll handle this matter.
Welcome back to the courtroom, and buckle up because today's courtroom drama is anything but ordinary. On one side, we've got Tyrone McFarland facing a stack of charges from trespassing to disorderly conduct. But his day in court takes an unexpected turn when questions of mental competency, past hospitalizations, and even wild outbursts enter the mix. And just when you think things can't get more chaotic, another defendant steps into the spotlight, Mitchell Myers, accused of pointing guns at his own parents, discharging firearms inside the family home, and spiraling under the weight of untreated mental health struggles. Two very different men, two very different stories, but both reveal just how thin the line is between justice, mental health, and public safety. Stay with us, because you're about to see judges balancing compassion with hard consequences, families torn apart, and legal battles that could shape these men's futures
Handle this matter.
forever.
Hey, look, Sam.
Okay, I'm gonna have yep, you guys can just be behind me and see over my opponent here, please. Just because there's stuff over there. All right, McFarland,
Yeah,
over there, sir.
I speak to Shadow once again. Yeah, I can't laugh.
Sure did. All right,
He's following with me again about falsifying charges on me.
sir, we are in court.
Yeah,
You are not going to be swearing on the record.
my man.
Am I clear on that?
Yeah, clear that.
Okay, remove your hood.
Oh.
We're in court. Thank you. We are on the record in the matter of the city of Wyandotte versus Tyrone McFarland, 251228 and 251025. And Mr. Serrano, your appearance, please.
Your Honor, good afternoon. Richard T. Serrano, P33828. Today, Your Honor, I appear as Deputy City Counsel for arraignment purposes only on behalf with my client, presently in custody. And Your Honor, today I've had the opportunity to speak to him regarding the nature of the charges, all maximum penalties
So
involved.
here we go. Case 1 officially begins. Tyrone McFarland, already facing pending charges of trespassing and fraud, is back in court after another arrest. The judge wastes no time making it clear. Swearing, hoods, and interruptions won't fly in her courtroom. Notice how quickly she asserts control. This isn't just about respect. It's about maintaining order in what could spiral into chaos fast. And here's a key point. McFarland's attorney waives the formal reading of charges and enters a not guilty plea. That's a pretty standard move, but it sets the stage for what's coming. A bond battle that reveals McFarland's messy history.
All maximum penalties involved. He understands them. Also, he's been explained his advice of rights. I believe he understands those as well. Today, we waive formal reading as to all charges.
Stop.
Your fault, that does. You don't say that.
Excuse me.
I
You'll
don't know if you talk.
you stop. You will have an opportunity to speak in a moment. We have a recording. It can only pick up one person at a time, so do not interrupt, please. Okay?
Oh, God.
We are waiving formal reading, standing mute, as for a plea of not guilty to be entered, Your Honor.
I'm not guilty.
Yes. So, sir, for the record, your name, please.
Tyrone McFarland.
All right.
This is Tyrone McFarland.
All right. The court is going to waive the formal reading. Enter a plea of not guilty on your behalf on both matters. The court will note that Mr. McFarland had a pending matter for trespassing and fraudulent schemes and disguises from the date of that offense was July 11th. That was originally scheduled for October 8th for an arraignment pretrial. And based upon Mr. McFarland being in custody on the disorderly conduct matter, the court pulled that case that was originally scheduled for October 8th to today's date as well. So that's why both matters are being heard for an adjournment or for arraignment. So we will schedule these matters for pretrial September 3rd at 9:45 a.m.
The water?
Yes, sir.
And, Well, the be right back here.
Yes, sir.
Yeah, no. But we I gotta stay in Wyandotte because if I leave, I can't make court. And the police keep trying to put me out of Wyandotte.
Well, counsel,
Tell some, but tell some, you know.
so counsel, as to bond.
Your Honor, my client tells me he's not on probation or parole, has nothing pending, according to what he tells me. He's not working. He does this family support four children.
So what did I tell you? Excuse me, myself. What did I tell you about interrupting?
Did you
Okay.
catch that? Tyrone is worried that if he leaves the city of Wyandotte, police will try to put him out. This shows us something important. He doesn't fully understand how jurisdiction or bond conditions work. Judges aren't deciding based on geography. They're deciding based on criminal history, stability, and risk to the community. This is where you can already see the cracks. Tyrone interrupts constantly, undermines his lawyer's strategy, and struggles to follow courtroom procedure. What do you think? Is this defiance? Or is it deeper confusion tied to his competence?
What did I tell you about interrupting?
Okay.
Please continue.
You know, that's a garbage can. That's why I eat there. At a garbage can.
I'm
On
sorry.
the street. At a garbage can.
Sir, please don't interrupt. Let your attorney
Oh, you're my bad.
make the record. Thank you.
Yeah.
He does support 4 minor children, Your Honor, he tells me. He's not working, nothing pending. He tells me he's never failed to appear in court before. But the court has the records in front of it, so I'll leave it in the court's discretion. These are not serious charges, Your Honor, but I think he has a failure to appear in court in the past. But we'll leave it in the court's discretion, either a personal bond or a bond he can expect to post. Thank you.
I can't afford no bond. I can't afford it now. I ain't working on for a bond. I ain't got a bond. I do constant bond.
Okay. I don't know what all my body condition sheets got that were here. You know, here before I left you, my head hurts. All right, well, sir, let me see here. I know you've been here a number of times.
I think you need one judge.
What's that?
It's probation.
All right, thank you. I need actually 2 of them, but I think that actually they don't have it. I think Angela has them on her computer. Okay, so I believe, sir, you were recently in custody, and then
What about the whole time? But no.
Sir?
The whole time?
yes, please let me talk.
And you did.
Let me talk.
Do it again.
Let me speak. I need to make a record.
And here's the bombshell. The judge reminds everyone that McFarland was previously deemed not competent and not restorable. Translation: a court already decided he couldn't understand proceedings well enough to stand trial, and doctors didn't think treatment would fix it. Normally, prosecutors can petition for guardianship or treatment pathways, but here they didn't. Instead, Tyrone was simply released. And what happened? He's back, facing new charges. This raises a huge question for the justice system. What do you do when someone can't be restored to competency, but also keeps committing
I need to
crimes?
make a record. And then, and I believe that Mr. Lloyd represented you, and you were deemed not competent and not restorable. And the prosecutor at that time had chosen not to petition the probate court for guardianship based upon the determination that you were not confident and not restorable. And so then you were released from custody, and then it appears on July 10th of 25 that you picked up a matter in River Rouge. And then July 11th, then you picked up 2 counts in Wyandotte. So, what happened in the matter in River Rouge? Do you have a pending court date?
Yeah. That was good, but it really put me in the hospital. It really put me in the hospital. Something small like that. He put me in the we did one comfort hospital. Something small one day. That was their fault. Yeah, what was it? They called the one hospital. They came out there and go in there, come out and get one. Shake your phone. They been around there to beat y'all up. With feed, beat y'all up, so they play. Beat all I couldn't go nowhere. Could go to the bathroom and watch me. I tried to talk to somebody, I couldn't talk to nobody.
Okay, now
Yeah, nobody. Why you like that?
that was while you were in the hospital.
Mm-hmm. Yeah, very. You know, he took my face.
All right, sir, you reside, who do you reside with in Detroit?
Mm-hmm.
It says it has your address on East Jefferson in Detroit.
Say what?
The address we have for you,
I live in Detroit. I had that in Detroit. Except for the streets everywhere. I live on the street. I'm always in street 0, my address 000. 6 times.
okay. All right, well, here's the court's going to,
And I want a place to sit. And I don't
want
want
a place to stay, is that what you said?
I want a place to sit.
You don't want a place to
No.
stay? Okay.
Here's the doctor. If I say the doctor, that you are. You can't take your parents to keep you on, The one with the E-ball in the world. I get the E-ball. We all change, there you are. Yes, we are.
Well, it shows that you're ordered to have a tether. Is it 25th District Court ordered a tether?
I want no goddamn jail. Put no goddamn jail because the fuck that's misdemeanor.
Excuse me,
Put no jail for no goddamn misdemeanor.
sir.
Put a,
As I stated before, we are in court. You're not going to be swearing on Monday.
what you want? We gonna put your teller on the head. I gotta go to county jail, put the teller on.
Sir, did you hear my question? My question was whether or not you were ordered to have a
Whoa.
tether.
And there it is. McFarland erupts, swearing at the judge and demanding to be sent to jail. Outbursts like this can destroy any chance of leniency. Judges are used to stress in the courtroom, but profanity and defiance only confirm concerns about instability. And here's the irony. While McFarland says he wants jail, his attorney is fighting for a bond. This contradiction is classic in cases involving mental health. The defendant's words can directly sabotage their defense strategy. If you were the judge here, how would you balance compassion with community safety?
You were ordered to have a tether from the 25th District Court. That's
No. You know what? The only time I had to tell her with you said I'm gonna take girls and blood in the back of my hand. You put a teller with then. Well, July 7 of 2025.
July 7th.
Yeah.
Ordered a tether for you.
Yeah, from July 7 all the way till May 10 of 2024, 2025, May 10 and the teller.
Okay. All right. Well, here's what I'm going to do. Given that Mr. McFarland was in custody previously and deemed to be not incompetent and not restorable, and due to the prosecutor's failure to petition for Mr. McFarland to get treatment that he needs.
I'm not mentally ill. I'm physically disabled. Well, not mentally disabled. I'm physically disabled. Well, not mentally disabled. So that ain't talking about me anything. That's the truth, sir. That's the lie you can tell.
Sir, that
Yeah.
was based on the opinion.
The proof already competent. Proof already competent. I articulate well.
That's fine, but you also articulate well by trying to speak. So, based upon Mr. McFarland not having any stable housing, whether
I want to stay, doc. I want to stay.
000 or
Shut up. Can I tell you something? Do you understand? Can I tell you something?
no,
I want to stay. I want to stay.
sir.
The state wants me for everything I do, but they don't do it.
I will give you an opportunity to speak in just a moment. Given defendants' prior criminal matters, the pending matters, thank you, that he currently has in this court, and now he has this matter that he was arrested for last night. And it also shows,
He's bad for me.
you're gonna have to wait, sir.
I hope I get cancer, but I get cancer and kids. All I get on my body. I got a piss. I got a piss, you guys. I got a piss. I'm pissing myself. I got a piss.
Sir,
I got a piss now. I'm gonna get a piss now. Fuck, I piss my goddamn self.
have,
That's another damn case.
sir, Sir,
What?
you just used the,
I gotta eat crab, but I feel. I'm fishing 90 times a minute. I got chancellor. I got chance. Gotta go piss.
okay, great. You can go to the bathroom.
Thank you.
Sometimes it's
Good job.
on each matter not to be, you can do tentative treatment. Otherwise, you're not to be released without a tender.
Thank you, Your Honor.
Thank you.
You can't make this up. Right in the middle of serious bond considerations, Tyrone blurts out that he needs to use the bathroom, multiple times, escalating with profanity. Now, this might seem comedic on the surface, but think about it. This is also a sign of disorganized thinking and impulse control problems. For the court, though, it's disruptive. At this point, the judge has to decide, does she keep bending to accommodate him, or does she tighten restrictions? The ultimate ruling here, no release without treatment, shows exactly how judges walk that tightrope between rights and responsibility.
State of Michigan versus Mitchell Myers, 251225. And Detective, your name for the record, please.
Detective Chelsea Hampton, Wyandotte Police Department.
All right, please raise your right hand. You solemnly swear affirm testimony about to give this matter the truth, the whole truth, and nothing but the truth.
I do.
All right, thank you. You may proceed on the board.
On August 20th, 2025 at 20:51 hours, Wyandotte officers were dispatched to a weapons call at 525 St. John's in the city of Wyandotte. Dispatch advised the officers that William Myers stated his son, Mitchell Myers, was upstairs in his bedroom threatening his mother, Sherry Myers, with a gun. William stated Mitchell and Sherry were fighting over the gun. Officers arrived on scene and observed
Just when you
William.
think the drama's over, enter Mitchell Myers. And unlike Tyrone's case, which centers on disorderly conduct and competency, this one escalates to life or death stakes. Police are dispatched to a weapons call. Mitchell is accused of threatening his mother with a gun, and officers even recover evidence of a firearm being discharged inside the family home. This isn't just chaos. It's danger, plain and simple. Notice how the prosecutor immediately emphasizes Mitchell's bipolar disorder, possible schizophrenia, and paranoia. Mental health again takes center stage, but this time with the added layer of
Officers arrived on scene and observed William to be outside, stating his wife Sherry was still inside. Shortly after, Sherry exited the house, stating, "Please help me," and that Mitchell had a gun. Officers continued announcing police presence to exit the home. Officer Saltzman observed Mitchell walk through the home with a handgun in his left hand. Mitchell then went out of officers' sight. Officers heard numerous loud noises from inside the home. At 21:02 hours, Mitchell exited the home with his hands in the air. Mitchell was arrested by officers. No firearm was recovered on Mitchell. On scene, Sherry stated Mitchell suffers from diagnosed bipolar disorder, and the family believes that he has schizophrenia and that he has been extremely paranoid recently. Sherry stated that Mitchell was claiming William took firearm ammunition from a locked safe and was selling it. Sherry explained to Mitchell that William would not do this, which started a verbal argument. Sherry stated Mitchell claims he is the only one that can protect the home. Sherry stated she was looking for ammunition in Mitchell's bedroom when she saw numerous firearm magazines on the floor. Sherry retrieved these magazines and also located a loaded Luger handgun on the floor, which she secured into her purse. Sherry then confronted Mitchell about this, who was sitting on the bed. Sherry then observed Mitchell to be feeling another firearm in what she described to be shiny underneath his buttocks. Sherry then asked Mitchell numerous times why he had the firearm and to give it to her. Sherry then described the altercation to be physical when she was trying to take the firearm. Sherry stated Mitchell claimed he would harm himself at that time. Mitchell also claimed he would assault William if he came upstairs. During this altercation, Sherry had her daughter, Miranda Myers, on the phone. During the altercation, Sherry had her daughter, Miranda Myers, on the phone. Miranda stated that she believed Mitchell was going to shoot Sherry while hearing the altercation. On scene, William stated he was in the basement on the phone with dispatch while this altercation occurred. William stated he believes Mitchell wants to kill him. William stated there were 4 firearms inside of the home. The Myers expressed concern that Mitchell was high or intoxicated due to drinking and abusing his prescription medications. I was advised Mitchell had a VAC of 0.054 during booking. During his arrest and booking, Mitchell made statements about discharging the firearm inside of the home into William's computer. Mitchell had 19 22 caliber bullets on him in the rear compartment of a fanny pack, which was collected during booking. A search warrant was executed on the home. Officers seized 4 handguns. During the search of the home, it was confirmed Mitchell had discharged a 9mm silver Browning handgun into the laptop computer belonging to William. The handgun was located on a table in the basement just outside the room with the laptop. A spent 9mm casing and several partial lead cores and copper jacket fragments were collected from the basement floor. A bullet hole was observed through the laptop keyboard, which traveled through the table and into the cement floor.
They provide examination and surgery conclusion of probable cause may be found in those offenses. All right, counsel, your appearance, please.
Your Honor, good afternoon. Richard T. Serrano, P33828, appearing on behalf with my client, presently in custody. Your Honor, my client would like a formal reading of the complaint, please, of all charges.
Sir, your name for the record, please.
Mitchell Myers.
All right. The court has before it a complaint that alleges on August 20th of 2025 in the city of Wyandotte that you did intentionally discharge a firearm in a facility that you knew had reason to believe was a dwelling or a potentially occupied structure in reckless disregard for the safety of another. This is a felony charge. The maximum penalty upon conviction is not more than 10 years in state prison and or $10,000 fine, mandatory forfeiture of the weapon or device. Second count is felony firearm. It's alleged on the same date and location that you did carry or have in your possession a firearm, that being a handgun at the time he committed or attempted to commit a felony. That means that this is a dumping. It's a felony charge. The maximum penalty upon conviction is 2 years consecutively with and preceding any term of imprisonment imposed for a felony or attempted felony conviction, mandatory forfeiture of the weapon and device. Counsel, are you satisfied with reading of the charges?
Yes.
The court's going to enter to the next standing on your behalf, sir, and schedule this matter for probable cause conference on September 4th at 10 a.m. Counsel asked to bond.
Your Honor, my client tells me he's age 30. He lives with his mother and father who support him. He's not working presently. He's not on probation or parole. He tells me he has nothing pending in a criminal as to criminal matters. Your Honor, I don't believe he's never appeared in court before or never failed to appear in court before. Seems to be something that's out of character for him. Your Honor, we ask the court to consider a personal bond with some safeties, of course, to the family members and with conditions. If not, a bond he reasonably expect to post. Thank you.
All right, and, sir, why don't you work?
When I was in third grade, I was put on the medication and I took it. Well, I dropped it. And I failed sixth grade, and then 13 years after I started taking it. And after I stopped taking it, I don't know how other way to put it. I basically just lost my personality and any drive to do anything, any drive to make friends or talk to people or go out in public. I just recently went back on the medicine. Not sure how long ago that was, like maybe 4 or 5 months ago. I've been looking for work, but they don't want me because I don't have a driver's license and I haven't worked for 10 years.
Okay, so, sir, if you are not permitted to go back to the home, where could you go to stay?
Friend or maybe go to rehab.
Okay. And have you ever failed to appear in court for any reason, sir? Sir? I can't hear you. Have you ever failed to appear in court for any reason?
This is the turning point. The prosecutor flat out tells the court, Mitchell has serious escalating mental health struggles and his family fears for their safety. That's heavy. Add in his unemployment, lack of stable housing, and access to firearms, and you've got a recipe for tragedy. The defense argues this was out of character, but the evidence paints a darker picture. And when judges set bond, they don't just look at the defendant. They weigh the safety of victims, the community, and even the defendant himself. Here, it all points toward one conclusion: a steep bond with tight
For any
restrictions.
reason.
Have you ever felt in
No.
Patty, would you like to address that?
Yes, Your Honor. I do have serious concerns for the complaining witnesses, their safety in this matter. Obviously, they both expressed that Mitchell has struggled his entire life with mental health issues and that it has been escalating recently. I would just like you to take that into consideration when deciding bond.
Court just has some serious concerns with safety of the complaining witnesses in this matter, as well as Mr. Myers not really have any stable residency to stay at in the interim, not having any ability to not having any reason that would tie him to the community as he doesn't work. As well, the court, based upon the nature of the allegations, the seriousness of the charges, safety of the public and the complaining witnesses, the court's going to order a $50,000 10% bond. You, in the event bond is posted soon, and even in the event that you remain in custody, you're not to have any contact. Mr. Myers, where'd you go?
Oh, I'm sorry. I'm
You're
right
not
here.
you're not to have any contact with William Myers or Sherry Myers. That's phone contact, text message, email, social media, anything of the like. No third party. You cannot call them from jail. So if there's somebody that you think you're going to call to help with your bond, it's not to be them. You're not to return to the home on St. John's, except with the assistance of a police officer to get us the personal belongings. You're not just to consider alcohol or dogs unless prescribed. You're not to possess or necessity firearms and any weapons. And you are not to be released without GPS and alcohol until you can Wayne County Jail. Any questions regarding those conditions?
Yeah. Does that mean I'm going to jail?
Well, do you have $5,000 to pay, sir, or somebody can pay that for
I
you?
wanted to call a bail bondsman.
Okay, you can call a bail out and just not your parents. The court also, sir, I just want to remind you, because we did not tell you previously, you do have a right to have an attorney. If you cannot afford one, you could have one appointed to represent you. The court signed the appointment attorney for felony matters. You also have the right to use your innocence if it goes beyond reasonable doubt. You have the right to have a trial by a judge or by a jury, and you also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand all those rights?
Yeah.
Okay. All right, sir. We'll see you back on September 4th. Thank you. All
Thank you, guys.
right, you're off, brother. Okay.
What was that?
Okay.
Go ahead.
Two cases, two men, two very different outcomes, but both pointing to the same collision of mental health and the justice system. Tyrone McFarland, deemed incompetent in the past, now ordered to remain in custody unless treatment is secured. Mitchell Myers, accused of threatening his parents with guns, firing into a laptop, and spiraling under paranoia, now facing felony charges with a $50,000 bond. Both remind us of the same reality. When mental illness intersects with crime, the courtroom becomes more than a place of law. It becomes a battleground for safety, treatment, and accountability. What do you think? Should the system lean more toward compassion or consequences in cases like these? Drop your thoughts in the comments below. And if you found this breakdown as shocking as we did, make sure to hit that like button, share this video with someone who follows courtroom drama, and don't forget to subscribe for more jaw-dropping cases, real rulings, and expert analysis.